Everyone, and welcome to the Safety Act webinar, Help in Getting Your Solution Qualified for Safety Act Protection, presented by the Security Industry Association and PSA Security Network. My name is Krista Frindelli, and I'm the Marketing Coordinator for PSA, and I just want to welcome you today. We understand that your time is valuable, and we really appreciate you spending some of it with us. Just a few housekeeping items. If you do have any questions, please type those into the questions panel on your control panel, and there will be a live question and answer session at the end of the presentation. If you have any technical difficulties, chat will be monitored, and we'll do our best to get you up and running if you send a little message through to us. Right now, I am going to introduce Don Erickson. He is the CEO of the Security Industry Association, and he is the one who initially brought the idea of this webinar to PSA. The Security Industry Association does a lot of work to protect and help the integrators on the Safety Act, and it's really valuable for us to know what they're working on and how they can help us. So PSA is very excited about this relationship with SIA, and we're looking forward to more programs and partnership opportunities in the future. Prior to his involvement with SIA as CEO, he served as the Director of Government Affairs for almost 6 years. So he's been very, very involved personally in this process. Don, thank you so much for your willingness to share information and to support PSA in this way. And with that, I'm going to hand the presentation over to you.
Great. Thanks very much, and thanks for the opportunity for SIA to work with PSA on this webinar. I think it's a very, very timely topic, and I also want to congratulate PSA on having a very, very successful PSA Tech Conference. It was a pleasure for me to be out there and speak to a lot of your members, and SIA views PSA as a very, very important strategic partner. And for that reason, it is my pleasure to be a part of this webinar today, and really excited to introduce Brian Finch. Brian is someone I've known for a number of years here in DC. I mean, simply put, he is one of the real experts in how to navigate the Safety Act process. And he has been testified on Capitol Hill and been recognized by a large number of stakeholders for his expertise. And I really did not think of any other person who I thought would be best to present on Safety Act today other than Brian. So with that, Brian, I'll turn it over to you.
Great. Thanks so much, Don. I really appreciate it. And thank you personally for including me in this webinar and thinking of me. And Don mentioned we've known each other for a number of years, and I think very highly of him and his organization. And I think the relationship between SIA and PSA, I'm sure, will be a very positive one for everybody who participates. Having been to a number of the SIA conferences and seeing their access and their knowledge and expertise that they can share, it's truly one of the more beneficial organizations that you can belong to. And again, Don, thank you for recognizing the work that I've done on the Safety Act over the years. I'll let you hand out the accolades. You and my mother can do that. But I'll just say I've certainly been involved in the Safety Act for a number of years, and it's my pleasure to share my experience and go through the Safety Act from start to finish and answer any questions any of the participants might have. So with that, hopefully everybody can see the first screen, and what I'm going to do is I'm going to run through a presentation today describing how the Safety Act came about, why it came about, then how it actually functions, as well as what are some of the key drivers in making sure that your technology or your service can get Safety Act approved, and why this is so critical in the very competitive security environment post 9/11, and really as we go and get further away from 9/11, what can distinguish you from your competitors and why it's critical for your investors to think about the Safety Act in order to help drive your business. So with that, I'd like to start with a review of the legal environment. And of course, I'm an attorney. Hopefully nobody holds that against me. My wife once paid a compliment to me in saying, I really don't think of you as a lawyer anymore. And I actually take that as a compliment. But this is a legal process, and you do have to start with the concept of why were people concerned about liability? Because in part, pre-9/11, there were a number of lawsuits against entities that were involved in terrorist attacks. Obviously, September 11th was not the first terrorist attack. It wasn't even the first terrorist attack on American soil. In the 1990s, for instance, there were some very significant events. We all remember 1993. The first World Trade Center attack, where a bomb was driven into the parking garage of the World Trade Center and detonated. Fortunately, at that time, it only caused a few deaths and some injury, but it still caused a loss. And what happened was that the Port Authority brought some claims against the manufacturers of the fertilizer, saying, amongst other things, that they negligence for failing to design and manufacture a less detonable product. There were some product liability design defects because the fertilizer was unreasonably dangerous and defective, and there was a failure to warn both functionally fertilizer. It's what helps makes our food grow. But it is also a basic component for much of the explosives that are used in the world today. And many of the IEDs, for instance, that we see in Afghanistan are ammonium nitrate based. And so there was a lot of knowledge that this could be used as an explosive. And so hence the claims that we saw post the 1993 World Trade Center attack. And what happened was that the court examined these claims and they dismissed them, holding that it wasn't reasonably foreseeable that the terrorists in this case would have used fertilizer to make bombs. And the court specifically said no jury could reasonably conclude that one accidental explosion 50 years ago, one terrorist attack 30 years ago, scattered incidents over the last 30 years would make the incident like the World Trade Center bombing anything more than a remote or theoretical possibility. I want you to keep that in mind, and I want you to also think about that. Here we have a product that everybody knows is used as a base for explosives. It's commonly used for that. But here, in this instance, in a terrorist attack, the court said, no, we really don't think that it was foreseeable that a terrorist event was going to occur, so we're not going to hold the fertilizer manufacturers accountable, legally at least. Okay, fast forward to 1995, another much more deadly, much more devastating terrorist attack, this time in Oklahoma City. Again, you saw some claims against the fertilizer manufacturers, similar claims of negligence and strict liability against the manufacturers of the fertilizers that was used to create and explode the bombs. Similar claims by the plaintiffs alleging liability against the fertilizer manufacturers. Similar results at the end of the day. The court here also found that the fertilizer manufacturers had no duty to plaintiffs to prevent them from harm, that the products themselves were not unreasonably dangerous and defective, and what I have underlined is the key point. The intervening actions of the terrorists destroyed any proximate cause argument that the plaintiffs might have had. That's a great line if I was a first-year law student, and everybody would understand that easily. In simple layman's terms, which is the way I like to operate, is that, hey, it wasn't our fault. The terrorists built the bomb, and they exploded it. It wasn't we, the fertilizer manufacturers, that did that. So go after the terrorists, not us, the explosives manufacturers. And that's exactly what the court held in this case. They said that the intervening actions of the terrorists, them taking the fertilizer and transforming it into a bomb, eliminated any direct causal link between the fertilizer manufacturers and the victims. And so the chain of liability stopped at the terrorists. So this sets up a very good legal environment. If you make a security product, if you make a product that could be transformed into something deadly, now you have not only one, but two separate court actions saying the manufacturer of these products that were perverted into something that caused death, destruction, and injury are not liable for a variety of reasons. That it's not foreseeable that these attacks would occur. The products themselves aren't inherently dangerous, and most importantly, it's the people who committed the act that are responsible, not the manufacturers. It's sort of the old guns don't kill people, people kill people type of argument, and a court memorializing that in litigation related to terrorist attacks. So going into 9/11, people, and following 9/11, people who were involved in security and were the victims of the terrorist attack, i.e. the landlords, felt fairly comfortable about the litigation that was popping up. And so you can see here that, as I was just mentioning, no specific duty, terrorist attacks were unforeseeable, etc. But you go into 9/11, and you see the same claims filed and the same defenses being offered that I had just mentioned, these right here, talking about no specific duty to protect the plaintiffs, unforeseeable events, so unique that they sever liability, etc. Similar claims were filed against Boeing, the manufacturer of the aircraft that were used in the 9/11 attacks, the security contractors, the buildings owners, etc. They all said, we want immediate dismissal. We don't owe any duty to the plaintiffs, and defendants couldn't have reasonably anticipated the actions of the terrorists. If you think about that for a second, if you're familiar with the investigations into the 9/11 attacks, by the government and independent agencies and independent panels, they all came to the same conclusion, that there was a failure of imagination on the part of the U.S. government to anticipate these attacks, and that helped contribute to their success. So if the government couldn't foresee the attacks, then why would you possibly think that individual companies, especially airframe manufacturers, security guard companies, building owners in Lower Manhattan who don't have access to anywhere near the intelligence or the resources of the federal government, why would they be held liable? And in this case, the court actually went in the complete opposite direction of what you saw pre-9/11. There, the court found that terrorist actions were, in fact, reasonably foreseeable and that, in fact, a duty could be owed to the plaintiffs. And they allowed the litigation to continue. The court very specifically said the danger of a plane crashing as a result of a hijacking was, quote, the very risk that Boeing should have reasonably foreseen. And that was in response to Boeing's argument that cockpit doors weren't for security against terrorists, they were for privacy and other purposes, but not for preventing a hijacking. And the court explicitly rejected that argument, which leads to my last bullet point, because it means it's a totally different environment for companies that provide security. It got even worse a few years ago when the Port Authority itself, hearkening all the way back to 1993, was found negligent in the bombing of the 1993 World Trade Center. The court found that the Port Authority was on notice. And because they were on notice, they had to take reasonable mitigation measures. Now, if you recall, everybody, one of the scenarios that came about as a result of that litigation, and one of the facts that was discovered, is that the Port Authority had conducted a vulnerability assessment in the mid-1980s in which they actually, with eerie accuracy, predicted the 1993 World Trade Center attack, where they talked about someone driving into the unguarded parking garage, parking their car, setting off a time-delayed fuse, walking out, and allowing a fertilizer base or another explosive to detonate, causing massive destruction at the building. Port Authority had that on the books, and they said, you know, we're not going to make any significant changes. And then 7 years later, that scenario played out. The court said, nope, in this instance, you were on notice. And I want you to not just think about it in the context of there was a specific risk analysis done, and because of that, there's liability. No, the court said in this case, notice occurs when the defendant knew or should have known, should have been aware that a terrorist attack was possible. And so why that is critical is that it throws out the argument that some people say, well, let's not examine our vulnerabilities, because if we don't examine our vulnerabilities, we don't have a track record and we don't have a public record or a private record even that will show liability or potential notice. In this case, the court said if you knew or you should have been aware, you're on notice, and now you have to take reasonable mitigation steps. And what are those reasonable mitigation steps? The reasonable mitigation steps could be ones that were previously considered burdensome, could involve circumstances where even the most stringent of mitigation measures suggested in the course of a vulnerability assessment would be considered reasonable. So the short answer to that is that nobody knows what's reasonable in that case. You know you have to do something, but you're not going to know until you get to a jury as to what's considered reasonable or not. And if you know anything about going to a jury trial in these cases, you know that it's expensive and the outcome is exceptionally unpredictable. So it's a very difficult decision at that point. Now, keep in mind that this decision was actually ultimately overturned only for one reason. And that one reason was that the court found that the Port Authority in this particular instance wasn't liable because they were a governmental entity, and so they were immune by state law. But other than that, the court set that dangerous precedent with notice and reasonable mitigation steps. So you're stepping into a very difficult liability environment. So that leads to the question for participants on this call and others, well, why are they going to sue me? I'm not the terrorist. Well, are you going to recover from terrorists? The answer is no. That's been tried before. The widow of Daniel Pearl, the Wall Street Journal reporter who was killed in Pakistan, filed a lawsuit against Al-Qaeda, a dozen reputed terrorists, Pakistan's largest bank, etc. And the case was ultimately dismissed because nobody bothered to respond. Now, before a year ago, I would have said, you know, and if you can find somebody who can track down bin Laden and Al-Qaeda, you know, that'd be great. Now, we actually did find someone who could do that, and up until that point, they hadn't been successful. But the point is that I don't think the U.S. government is going to deploy military assets to file, to serve these complaints on terrorists located in foreign countries. So it's extremely difficult to get them to show up in court and essentially pointless. What about state sponsors? There's lots of cases where potentially there are state sponsors of acts of terrorism. A key case here is the Beirut bombing all the way back from the 1980s. A federal judge in that case ordered Iran to pay close to $3 billion to the relatives of the military personnel killed, as well as the survivors. However, even the judge acknowledged that was a symbolic attack because, as we all know, Iran's estranged from the United States, denied responsibility for the attack, and didn't even respond to the lawsuit. So what's the point? Who's left to recover from? Security providers, including integrators and property owners, are the deep pockets. In other words, the plaintiff's lawyers are going to look around and see not only who can I sue, but who can I sue that will actually write a check at the end of the day. And that's you all. Got to remember, too, that now even more strong recommendations are flowing out. The New York Police Department has issued a security engineering document talking about things that can be done to protect buildings, perimeter security, building design, access control, emergency preparedness, and so on. And this is setting a bar for property owners, at least in Manhattan, with respect to what needs to be done in order to protect those buildings. And there's more and more requirements being placed upon property owners to do something. But again, the question is that reasonable? You have to remember, too, that litigation is going to happen. The key point here is that there were a number of people interviewed after the 9/11 cases were resolved and the compensation fund. A lot of those folks said that they felt like people were being paid off not to go to court and they were going to sue under any circumstances. Some even said, I'm looking for justice, someone held accountable. There are people who did not do their job, and that's why they were suing. And if they could do it again, some people would sue and not participate in the compensation fund. They felt dirty after taking the money. The legal bill was hundreds of millions of dollars for some of these defendants in these cases. Certainly not anything anyone wants to pay. And then you have to remember, too, and really the key point here, is that families who didn't sue and participate in the compensation fund were receiving an average of $2 million in compensation, while those that did sue and settled out of court and dismissed their claims were getting $5 million on average from the 9/11 attacks. So there's a strong financial incentive to bring litigation. In other words, it's going to happen. Be careful about that. So what do you do now? What are your options? You can get additional terrorism insurance. That's possible, but it can be expensive. It only covers so much. Can you get indemnification and waiver of claims from your customers? Possibly, but I'm not sure that that's actually going to happen. Can I only do business with the U.S. government? That can help liability in some aspects, but it can also make you a greater target. Because remember, the U.S. government can't be sued in most cases. It can only be the contractors they deal with. Do you walk away from the security market altogether? I think for most people, especially on this call, the answer is no. You really don't want to do that. So Congress answered with the Safety Act. And what is the Safety Act? The Safety Act stands for Support Anti-Terrorism by Fostering Effective Technologies. Now, Congress, God bless them, got it wrong with the name in and of itself. It refers to technologies, and that's a bit of a misnomer. The Safety Act applies to both products and services. And in the case of the integrators, it's not just the finished system, but the services surrounding it, the installation, the maintenance, the operation, the training, etc. All that can be covered under the Safety Act. Safety Act is part of the Homeland Security Act of 2002, the law that created the Department of Homeland Security. And what it does is that it eliminates or minimizes liability for sellers of anti-terrorism technology should suits arise after an act of terrorism. In other words, if there's an act of terrorism and you have these Safety Act protections, you can have strong liability protections. These protections can only be obtained by submitting an application to DHS. You don't just self-certify. You actually have to go through an application process. Here's another critical point to remember, too, that I'll talk about later as well. Protections apply under the Safety Act even if the approved technologies are sold to commercial customers or if the attack occurs abroad, so long as U.S. interests are implicated, i.e. economic losses. You install something in Canada, in Mexico, in Europe, there's a harm to U.S. person, to U.S. property, or to economic interest to cause a disruption in trade, Safety Act can apply. It applies to commercial customers as well, meaning that it's not just something if you sell it to the TSA or Customs or the Defense Department where you get these liability protections. You sell it to a football stadium, you sell it to Disney World, you sell it to a shopping mall, you sell it to a chemical plant, and that product or service is Safety Act approved, it applies in those circumstances as well. Now, one key thing to remember here, too, is that act of terrorism is defined very broadly under the Safety Act. You can see it here. An unlawful act that causes harm, including financial harm to a person, property or entity in the U.S., U.S. air carriers, uses or attempts to use instrumentalities, weapons, or other methods designed to cause mass destruction or injury. What does that really mean? That means basically anything could be an act of terrorism. It could be foreign acts of terrorism. It could be domestic acts of terrorism. It could even be cybersecurity events. All of those are covered under the Safety Act. What's critical here is that that is one of the broadest definitions of terrorism in the United States Code, in federal law. A number of other definitions have limitations on them. It has to be an act of terrorism conducted by an entity recognized as a terrorist entity by the State Department. It can only involve foreign terrorist acts. It can only involve certain weapons of mass destruction, etc. None of that is present here with the Safety Act. So it could be almost anything that is covered under the Safety Act. Now, under the Safety Act, there are two levels of protection, designation and certification. Let's start with designation. Designation provides functionally a cap on damages and a number of other benefits. First, claims can only be filed in federal court. That's a good thing. Those are more predictable courts. They have stronger rules of procedure. The federal judges are lifetime appointments, and so they're not motivated like you might see someone say, let's say in Texas, where judges have to get reelected, and so they like to be plaintiff friendly. So that's a good thing. Damages are capped at a level set by the Department of Homeland Security. Key point, when you go through the Safety Act process, one of the things that the department looks at is the amount of insurance you carry for acts of terrorism. Let's say it's $5 million. The department will say, for your security integration technology, you have to maintain $5 million in insurance. And what that functionally means is that you don't face any more liability than what your insurance amount is. If you think about it in an auto policy analogy, let's say you buy an auto policy for $50,000 in property damage, and driving in, you spill your coffee, you're texting, you manage to hit 3 Bentleys and a Ferrari on your way in. That's more than $50,000 in damage. But if you were, there was a Safety Act auto policy, your maximum damage is $50,000. Nothing on top of that is paid out, no out-of-pocket payments. Very good thing. No punitive damages and no prejudgment interest. Let's say, again, with a $5 million scenario, there's an award for $5 million, one of which is for $1 million of that is for compensatory damages for actual loss. $4 million is for punitive and prejudgment interest. In that case, the $4 million in prejudgment interest and punitive damages is wiped off the books, and only $1 million, excuse me, which is covered by your insurance, is actually payable under the Safety Act. And then there's recovery as well, reduction of the award by recovery by amounts that the plaintiff received from collateral sources, i.e. insurance benefits. Meaning that if a victim gets a $500,000 life insurance disability or life insurance payment, then that $500,000 is reduced from the award. So there's lots of things to cap damages and to provide some certainty. You're not looking at a 20, 30, 50, 200, $2 billion claim here. You know what your damages are going to be, and that's the maximum amount, and that's for an annual basis. So if you have 2 events, heaven forbid, in each are $5 million, you only pay the first $5 million. The second $5 million is unrecoverable. And then there's certification, which is the holy grail under the Safety Act. Under certification, sellers also receive a presumption of immediate dismissal. And what does that mean? That means functionally that if you get sued following a terrorist attack and you are certified, your technology is certified, and the plaintiffs say this alarm system, this perimeter detection system didn't work, and as a result we're going to get sued for $20 million as opposed to designation. Under certification, the first thing you do is you walk into court and say, Your Honor, we request immediate dismissal of this claim because we are Safety Act certified. The only thing the judge can do in that circumstance is to turn to the plaintiffs and say, can you demonstrate that the application was submitted with fraud or willful misconduct? Meaning, did you lie when you submitted your application about the effectiveness of your technology? Plaintiffs can't prove that, and they're not going to be able to do that given the process. Then you walk away from the lawsuit. It's over. You don't even have to worry about your $5 million cap. You just walk away. And importantly, too, under both designation and certification, customers are to be immediately dismissed from the lawsuit. Think about that from a marketing perspective for a second here. You sell your security technology to a chemical plant somewhere in Colorado, Texas, Oklahoma, New York, wherever. One of the things you can offer to them if you're Safety Act designated or certified is say, if you buy our access control solution, we give you a lifetime guarantee in the context of if you get sued and one of the claims against you, against you as a defendant, the owner of this chemical plant, is that you bought the wrong security access system, that claim gets immediately dismissed because you're not a proper defendant under the Safety Act. You walk away. You don't even need to worry about whether we lied about getting the Safety Act protections. Instead, you walk immediately away. So think about that from a marketing perspective. You walk in and you say, you buy our product, we guarantee you're going to get out of litigation related to the purchase or the use of this technology. Someone else comes in and they don't offer that. That's a very powerful argument for vendors. And I can tell you, I've experienced that from both sides. I've sat on the side of a company buying a technology, and I've sat on the side of companies that are looking to sell technologies. Whenever you bring that up, it's almost a no-brainer for the CFO in that case. And I will tell you, too, that the companies that have this, they market it like crazy. If you look at the trade publications, you'll see a lot of the big integrators that have Safety Act certification. They tout it in their ads, and it's one of the first things that they bring up in their presentations. So very powerful and something to think about. So how do you go after Safety Act protections? Well, as I mentioned before, you have to apply to the Department of Homeland Security. And the Department of Homeland Security has an application form that says it's looking for certain information. First is, what are you seeking coverage for? You can't just come in and say, we want to be Safety Act certified. Well, what are you seeking Safety Act certification for? Is it for your system as installed, or is it for the installation of the system? Is it for the maintenance of the system? Is it for the operation of the system? Do you have chemical, biological detectors on that system? You have to describe all that to the Department of Homeland Security and get a very specific, what they call, definition of the technology. How does it work? How is it provided? Exactly how does this stuff work? You have to explain to them, okay, here's the access control system, and here's how it's intended to work. Is it fingerprint? Is it retinal scan? Is it magnetic card readers, et cetera, et cetera? How does it talk to the computers? Is it linked to cameras? Is it linked to algorithms and alarms, et cetera? You need to explain all that. How do you know it works? What's your record of effectiveness? Do you test it? Do you collect information from your customers to see that it continues to work? How do you make sure that it continues to work? The Department of Homeland Security, when reviewing these technologies, doesn't like to see fire and forget technologies that you just deploy, and then if it breaks down 6 days later, you say, sorry about that. They want to see a record of continued effectiveness and that you have quality control in place to make sure that the product doesn't suffer any unusual breakdowns. Can you show that your product or service is repeatable? By that, I mean documented policies and procedures. It's great if you have the resident savant who knows how all this stuff operates and can do it from memory, but that doesn't help you from the Safety Act process. There has to be written documentation to show that it's repeatable and that it's reliable and that you know there's going to be some uniform measure of installation and activity as you go through the process. That's absolutely critical. Is it safe? Do you have an explosive detection system that 99% of the time will make sure that you detect liquid explosives, but 100% of the time is going to give anybody in a 30-foot radius a lethal dose of radiation? So those are the kinds of things, particularly for technologies, you need to be careful about and understand. Services as well, particularly in the security guard industry, you want to make sure that there's good use of force policies and other policies in place to make sure that nothing dangerous is happening with those services. So how long does it actually take to get one of these applications through the Department of Homeland Security? It takes about anywhere from 150 to 200 hours to put the application together. It's not simple, that's for sure. It's also not unreasonably painful. I mean, it is a process and it will take some effort, so that's where that figure comes from. Typical review time from the Department of Homeland Security. They have 30 days for what they call a completeness check, and that's to make sure that they have enough information to actually conduct a material review of the application. And if they determine that there is enough and that your application is complete, then there's a 3-month or 90-day review period in which they make the substantive review. And at the end of that, they will render their decision. So it's about 120 days for typical review time. They can extend a review if they like by 45 days. That does occur, not that often, but just be aware that that can happen. Realistically, the most likely outcome is that if you submit an application that just consists of marketing materials and it's fairly inadequate, You'll submit it, and 30 days later, you get a note back from the Department of Homeland Security saying, your application at this time is incomplete. We need more information. Here it is, and they'll lay it out in a 1, 2, 7, 10-page letter back to you asking for further information. And then they will say, please feel free to call us, and we can discuss it to provide further information to you. And a lot of companies do get incompleteness letters on the first try. It's not unusual, and it's not necessarily a knock on the technology. It's just that sometimes the department feels like it needs more information, or frankly, they need more time to gather themselves in order to review the application. And the simple reality as to why there's a lot of incomplete letters is as follows. The Department of Homeland Security, like everybody else, has metrics for success. And one of their metrics for success is that we get to do one of these reviews in 120 days or less to render a decision. So the dirty little secret is that if an application is rendered incomplete, it doesn't count towards a 120-day time review. And so that's why you see a lot of you see a good number of incomplete letters, because that gives the Department of Homeland Security more time to conduct a review. If they really didn't have this time frame metric on themselves, what they do is they just declare it to complete, and then they keep going through the review until they had enough information to consider themselves satisfied. So what happens when you actually get a decision from the Department of Homeland Security regarding the Safety Act application? If DHS provides Safety Act coverage to an applicant, you'll get a written letter, and that decision will address the definition of the covered technology, meaning what exactly is covered, the duration of the coverage, how long the coverage lasts. Typically, it's about 5 years. Whether prior deployments are covered. Now, here's a key point. The Safety Act can be retroactive, meaning that if you submit an application in 2011, it gets approved in 2012, it can cover sales going back a number of years, all the way back to 2001, let's say. So long as the technology has been deployed in the same way and utilize the same processes or procedures during that time frame, the department will go back and cover previously existing sales in order to make sure that the liability protections are as broad as possible. That's a good thing for you, because that means you don't have to worry about going forward having all these great liability protections in place, but you did 15 installations in the past 5 years, and now you got to worry about all those not being covered or have to do some sort of contractual mechanism to resell the technology. That's not the case with the prior deployment. And whether you need to buy additional insurance in order to, maybe you have $5 million, the department wants to see $10 million in insurance. That typically doesn't happen, but it is a possibility. One other thing I'd like to add, too, is as follows. Now, when I talk about the duration of the coverage, it's typically a 5-year period. But it's a little tricky, because what happens is that anything deployed in that 5-year time frame has Safety Act protections for life. So basically, you get a 5-year window in which to issue products with a lifetime guarantee of Safety Act protections. If you don't renew at the end of that 5-year period, any future sales don't carry that lifetime guarantee, but the Safety Act protections for existing deployments continue. Now, if you are unsuccessful for some reason, you can refile an application, and there's no 3-strike rule. You can refile your applications as many times as you want until you get it right. The department may come back and say, look, we just don't think you have it together. We don't think this technology is even anti-terrorism, so you can keep filing, but until you make some fundamental changes, we're not going to give you liability protections. That rarely, if ever, happens. Usually it's you have to bulk up this area and you have to bulk up that area, come back when you do it. We'll help spell it out for you, and then you can get the liability protections. So diving even deeper into the needs for a Safety Act application submission, as I talked about earlier, the data and documentation is absolutely critical for the application process. This is a paper review process, and this is an important point. DHS isn't coming to your factory. It isn't coming to your installation sites to actually look and review the systems. It isn't going to test them on site. It isn't going to ask you to come to a national laboratory and run it up against one of their systems to measure it. It's a paper review, meaning that the department looks at documentation only, and they make their decision based upon essentially a filing that you provide to the Department of Homeland Security. So having enough data and having enough documentation is going to be critical to the process. Some of the key information that's required for the submissions include documented processes and procedures, as if I haven't said that enough, evidence of management and of a management chain quality control. They want to know that there's a supervision chain in place in order to make sure that the process is being quality controlled and that things are being checked. Audits, effectiveness reports to make sure that there's evidence that the product actually works as intended. It doesn't have to be, we caught terrorist X on X date. It's just that the alarms were tripped. Maybe it was a common criminal activity. Maybe it was used in the case of fire or other natural disaster. But those kinds of audits or reports to make sure that the system actually works. Points of contact with local law enforcement. If there's ever been an exercise where your system has been used, that's good to have. DHS fundamentally is looking for records demonstrating utility, effectiveness, and quality control. Those are the big areas for a Safety Act application. And gathering and interpreting the information is typically the most time-consuming part of the application drafting process. Where I get involved and where my team gets involved is that we usually get documents dumped on us, and they say, okay, here's all the manuals, here's all the data related to the submission of a to our particular technology. Go ahead and draft the application. We put it together, and it's up to us to look at it and make sure that it's presented in a way that is understandable to the Department of Homeland Security. Now, you can do this on your own, too. The challenge is that since it's a legal document, a lot of times we need to, lawyers get involved so you can put it together to make sure that it's framed the right way and it gives you the best liability protection as possible. And frankly, since we've done so many applications, over 100 at this point, that we know what it looks like and what a successful application should look like in this case. One other thing I'd want to mention, too, regarding quality control and effectiveness, one of the things the department really looks for, too, is the presence of a process feedback loop. Meaning that if there's a lesson learned or you discover new information or you discover a flaw in one system that could be identified in other systems, there's a process in place to integrate those lessons learned into your overall policies and procedures. The department's very keen on seeing evidence of that. Once the application is gathered, the application can be drafted. Typically, the way it works when we're involved is that a draft is produced containing numerous additional questions and information requests. We will go back and forth with the client in this case several times in order to make sure all the questions are ironed out and that the application, once final, is submitted to the Department of Homeland Security. I know we get accused of asking a lot of questions when we're drafting the application and sometimes asking, quote, the same question over and over again. And it's not that we're being repetitive or we're just ignoring information. It's just that we know what the Department of Homeland Security is looking for, and we know that when you make a statement, that statement has to be backed up with documentation or an explanation. So it's better that we ask the question on the front end than DHS on the back end, because that can result in untimely delays. What are some hallmarks of successful applications? Project managers. Project manager to set up internal deadlines for gathering documentation, to serve as a point of contact for additional information requests. That's always key. If many people are in charge, then nobody's in charge. And if no one's in charge, definitely nobody's in charge. So we always find it helpful to have one person identified within your company to manage the process. Having regular conference calls, whether internally or if you retain somebody on the outside, to review the status of the application and additional needs. The application process, at least on our end, moves as quickly as the data is received. If the information is received in a timely fashion, 7 to 14 days after the information was requested, then it's possible to have an application ready in basically a month and a half, 2 months, sometimes longer. Fastest we've ever done it was basically, I think, about 17 days or so, but that was a real crush project. Usually it takes about 2 or 3 months, maybe a little bit longer than that, to put together an application. So, if you're thinking all the way back to my discussion about post 9/11 liability, how do you manage your liability? The first and foremost is file Safety Act applications. Anything you do that has an anti-terror application, think about submitting a Safety Act application for that. Your security services, including physical security, screening operations. Your customers can weave Safety Act into procurements. You can do that too. If you're buying a sensor from a particular company, you're buying a camera, it's worth looking to see if any of those individuals have Safety Act protections, because you get the liability protection as well. Any number of technologies or services that you need to buy are already covered by the Safety Act, but there's plenty of room for more entrants in the field. And it really is, particularly considering all the cases that I mentioned before and the potential liability scenarios, the best way, and possibly the only way to manage your liability in the post-9/11 environment. A couple additional things I wanted to add too, especially from the vendor perspective, is that numerous procurements are now being tied to Safety Act approval, including chemical companies regulated under CFATS are requiring security vendors to be Safety Act approved. That was one of the critical things I saw when I was involved with some of the CFATS clients, is that they were demanding that the barriers, the perimeter control solutions, et cetera, be Safety Act protected. The universe of customers demanding Safety Act approval is expanding. Amusement parks, sports teams, in addition to critical infrastructure facilities, iconic real estate locations, and many of those are demanding that any technology they buy that's security-oriented be Safety Act approved. So that goes back to the marketing point. Absolutely critical at this point to think about the Safety Act at the very least and be cognizant of it, be knowledgeable of it, and be conversant about it when you're talking to your potential customers, to talk about what you're doing with it, whether you understand it and when you're going to pursue it, or if you have it, how it works. Here is a good example, by the way, of a procurement tied to the Safety Act. This is for the City of Los Angeles for their airports, buying security technologies. This is direct language from their procurement. The system implemented will be required to be designated and certified as a qualified anti-terrorist technology under the Safety Act. Again, direct language from the solicitation, from the RFP. We see more of that every day. We've seen any number of shopping centers that require it, for instance, because they're worried about their liability being, basically an open environment and the soft target. Airports are doing it. I mentioned others as well. So that, in a nutshell, is the Safety Act. Hopefully I didn't speak too quickly. I'm more than happy to take any questions at this time, should there be any.
Thank you so much, Brian. We did get a couple of questions in. So the first one is, how can a company market their Safety Act approval?
Right. Well, the first thing you can do is that you definitely are eligible to market your Safety Act protections. You can note that you're Safety Act approved. There's a website, www.safetyact.gov, that lists out all the Safety Act approved technologies. And now the Department of Homeland Security in the last month has official Safety Act approved seals that you can attach to your marketing materials. You have to agree to some terms and conditions from the Department of Homeland Security before you can use those, but they're fairly minor and not too onerous. But they're, basically red, green, blue seals depending on your level of protection. And if you agree to their terms and conditions, you can place that in all your marketing materials, kind of like an underwriter's laboratory seal of approval, that type of thing. So those are some of the things you can do. You can do press releases related to the Safety Act. You can make sure it's included on all your sales materials, et cetera. But those are some of the best ways to market your Safety Act approval.
Great. Also, if I'm going to apply for Safety Act protections, I have to justify the cost of applying to my CFO or my investors. How can I do that? And then for that matter, will the government charge anything for submitting the application?
Right. That's a very good question. So first and foremost, when you apply for Safety Act protections, there is no fee from the Department of Homeland Security for submitting it. It's a free process. The costs associated with it are the dedication of internal resources, as well as if you hire an outside consultant to help you, which some companies do, some companies don't, et cetera. But more often than not, you will see companies retain someone on the outside to help them get Safety Act protections. So then the question becomes, if I'm going to expend those dollars, we have limited budgets to do that. How can we recoup those costs in any way, shape, or form? Well, there's any number of ways to do so. First and foremost, there's the potential of the insurance benefits at the end of the day. Remember I talked about that you have to maintain terrorism insurance as part of the Safety Act approval process. Well, there are a number of knowledgeable insurance companies out there that are aware of the Safety Act and understand its benefits. So they can work with you if you have Safety Act protections to get an adjustment on your premium or your policy limits downward in order to recover your costs from the Safety Act approval process. So you might see, particularly over the 5-year timeline that I talked about with respect to when these technologies are approved, you could obtain reductions in premiums or the policy limits that would actually wind up being revenue positive, if you will, with respect to the cost associated with submitting a Safety Act application at that point. That's one of the key points. Doing that depends, in large part, though, on being, number one, having a good insurance broker who understands your approval and what it means. Number two, making sure your application is done in a way that brings the most benefits out of your insurance program and provides you the greatest spectrum of liability protections. And third, and most importantly, you negotiate the right number with the Department of Homeland Security. If they offer up a number and that's your insurance program and you just say, okay, fine, we'll do it, that's not really going to get you anywhere in terms of the cost savings. What it can get you, however, so that's why you want to look at it and say to yourself, okay, we got to make sure that we negotiate the right number with the Department of Homeland Security. And remember, it is a negotiable number at the end of the day. They can say one figure, you can say another, and you can go back and forth, and you can actually do that at any time frame and help realize the cost savings. And then, you know, another way to justify it, too, at the end of the day is what I was mentioning before, is the marketing benefit. The marketing benefit is clear. You know, these are protections that you cannot get unless you go through the Safety Act process. And so it's, you know, it could almost be viewed as a marketing item at that point in order to look at it and say, okay, if I have this, this is going to help me sell product because it's an end benefit to my customer who might even be able to build a little bit of a premium into our sales because we're giving them something that they wouldn't otherwise have access to. Conversely, one of the ways you can justify it to your CFO and your investors and others is that, boy, if we don't have this, we might be on the short end of the stick, if you will, when it comes to competition, because if we have other companies out there that are really promoting the use of their Safety Acts and promoting their Safety Act protections, they are going to have a leg up on us, and so we're going to be at a disadvantage, and so we might have to invest the resources, the time, in order to go through this process and protect ourselves and protect our market share.
Great, just a couple more.
Okay.
One is I've heard of companies that have been trying to get Safety Act certified for a year and a half and have had no luck. Is there any advantage to paying someone to help you through this process, and can it speed it up?
And I'll say this agnostically, recognizing obviously I help companies in this process, but I'll try and be as agnostic as possible. Yes, it can help. Because if you have someone who understands the process and has been through it before and has done worked on technologies like yours, they know what the Department of Homeland Security is looking for. And the critical thing to remember is that it's not just that they know what the department is looking for, it's that they're in regular contact with the department too. Personally, for instance, I talk to the director of the Safety Act office several times a week about various applications, and so we have plenty of conversations about trends of what the department is looking for. Are they emphasizing certain information more than they have in other applications, et cetera? So that can be very helpful. It also is helpful, too, because if you work with an outside consultant who understands the process, they can start you off on the right foot. And they can say, look, this is what a successful application is going to look for. These are the things we need to have up front in order for the application to go through the process. This is the kind of data we need, and we need it in order for this to occur. And I will be frank about it, too. We've had several instances where we've talked to companies about potentially going through the Safety Act process. We learned about their technology or their service. We learned about where it is in the maturity process, and we've learned about what they have available to them. And we've said to them, you know what, we'd love to help you. Here's what you need to do, but you need to wait because you're not quite there yet. And frankly, we don't want to waste your money to encourage you to go through this process when you're not quite there yet. You need to write down your policies and procedures. You need to gather the information on the economics or the effectiveness of your technology before you actually go through the Safety Act approval process. And then ultimately, which is always the case, if you hire somebody on the outside, and I know it's certainly true in my case, we're absolutely paranoid about making sure that we do a good job, and so we work as fast and as diligently and as effectively as possible in order to make sure you have a happy customer, a happy client, and everybody wants to satisfy their boss, but when we have multiple people we're reporting to internally, we make sure that we do everything right and we do it as efficiently as possible.
Great. So what would be a reasonable budget for both money and time to get through the process?
Well, I mentioned the time budget previously. Think about 150 to 200 hours, and that could be collective. That could be depending on the individual, whether it's a combination of the company or the combination of outside consultants, et cetera. It all depends on how it's put together. In terms of the budget, it really depends on the technology. I will tell you it's going to be in the tens of thousands of dollars. It rarely crosses the six-figure amount. It's much more likely to be in the low to mid five-figure range in terms of putting one of these together. But it all depends on the complexity of the application, how much you're trying to encompass, how well defined it is, and how put together it is. And it also depends too on how the process proceeds. Do you do a data dump on somebody on the outside like ourselves, where you just hand them all the documentation and say you handle it, or do you look at it and say, okay, we're going to retain you to help us, to say to us exactly what needs to be done. We'll put together the application, and then we'll send it back to you for editing. If you do that latter, it can be less expensive, but oftentimes we've found that ultimately really they cost about the same, maybe a little bit less on the latter side, maybe not. Because if you just give it to someone who knows how to do it, they run it through the process, they have the documentation, they have certain templates that can be used, and they put it through, and they get it done in a timely and effective manner. And we also work with you in order to make sure, like I talked about before, figuring out ways to recoup the cost. One of the things we'll do is we'll talk to your broker, and we'll talk to the insurance carriers, and we'll negotiate your insurance number with the Department of Homeland Security to see if we can't get you those savings on the back end. We don't always get that. We can't guarantee that. But we've certainly seen it where it's been a revenue neutral, if not a revenue positive process at the end of the day.
Great. Now, Brian, I do have a number of additional questions, but they get pretty specific. So
Okay.
I'd like to encourage anybody with those very specific questions to follow up with Brian. His contact information is currently on the screen, and I will also make sure to get you all an email with that contact information so that you can contact him directly. But the final question I would like you to address is, will the slideshow also be available after the webinar as a standalone document that we can send out?
I'm certainly happy to share it with anybody. So I can email it to you, Sharon, and you feel free to share it with everybody.
Great. All right. Well, thank you so much, everybody, for your time, and really, really great questions and conversation. And Brian, great content, and I hope everybody has a great afternoon.
Thank you, everyone.
Bye-bye.